This is Dr. David Schein, and welcome to Business Law 101. And so we're going to look here at agreements and activities in restraint of trade. These are illegal agreements. A relatively common one among real estate agents is to divide neighborhoods. So somebody might say, look, I'm going to take care of the Memorial Villages. I'm going to let you have River Oaks, two high-end agents. That is an illegal agreement in restraint of trade by dividing territories. And you run up against the Sherman Antitrust Act. Sherman Antitrust Act is the granddaddy. It started it was passed in 1890. A very interesting quick story behind it. The United States, of course, engaged in a horrible civil war. Over 1 million people, I think, died between the two sides, a great deal of hardship and suffering. But in any event, when they came out of the Civil War, the United States had its Industrial Revolution. And it was very dramatic to think about from 1865 to 1890, a fairly brief period of time. The United States reached a point where the robber barons, Carnegie, Vanderbilt, Rockefeller, Gould, J.P. Morgan, had become so successful so quickly that Congress was forced to pass the Sherman Antitrust Act. So pretty interesting path of development from the end of the Civil War till around 1890 when this law was passed. But the other part of this is price fixing. And in terms of price fixing, you have, again, the situation, and the feds hate this. Many of you know that for residential purchases under $1 million, most real estate agents across the United States, not all, but most charge 6%. Now, I can understand 6%. I do have some business in the real estate industry because that's usually split 4 ways. The buyer's agent gets a quarter, or some agreed percentage. The buyer's broker gets a piece. The seller's broker gets a piece, and the seller's agent gets a piece. So the things are being divided 4 ways. But in any event, the 6% being so uniformly applied across the board has become is a cause of heartburn for the feds and Department of Justice and so forth. Price discrimination is also illegal. Example of this is we used to have is you had a railroad car, and you go there and you say, hey, I've got a bunch of cotton growing here. You've got a siding up there. I'd like you to take my cotton to the mills, to the manufacturing centers. And the person says, well, I'll charge you 25 cents a bale. Somebody else comes along who the railroad doesn't like, and the railroad says, same person says, I want to run my bales of cotton to the market. And the person says, that'll be 50 cents a bale. Well, the other guy got 25 cents a bale. This guy got 50 cents a bale. And in most cases, that is going to be illegal price discrimination under Robinson-Patman. This is Dr. David D. Schein for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.